At the close of the case of the petitioner on 8th February 2021, counsel for first respondent and the second respondent announced the closure of their respective cases and invited this court to determine the petition on the basis of the evidence the petitioner had adduced in this petition and their earlier preliminary objections that the petition discloses no reasonable cause of action. Counsel for the petitioner filed an application for leave of court to reopen the petitioner's case by calling the chairperson of the first respondent to testify in her personal capacity through the process of subpoena and be treated as an adverse witness. In that application, counsel for the petitioner submitted that he was invoking the inherent jurisdiction of the court on account of there being no specific rule of court to support the application being urged on the court. In his supporting documentation, it was the position of counsel for the petitioner that the chairperson of the first respondent had sworn to affidavits in which he had made the positions to the effect that he would be available for cross-examination. According to counsel for petitioner, these were the positions or notes which the chairperson of the first respondent ought to be bound by. He submitted that in law, the statement that he was available for cross-examination was of the Evidence Act 1975 NRCD 323, and this should form the basis on which the court should order her to testify as a witness for the petitioner. He submitted further that it was the intention of petitioner to call her as an adverse witness pursuant to Section 72 of the Evidence Act. Counsel for petitioner failed to indicate to the court the nature of the subpoena he intended to issue and what kind of testimony exactly he was expecting the chairperson of first respondent to bring to his aid in her personal capacity. It must be understood that under Order 38 Rule 10 Sub 1, the writ of subpoena a party may issue to invite a witness may be a subpoena ad testificandum to compel the witness to testify, or ad tecum to compel the party to produce documents in support of the party's case. Counsel for petitioner variously said that the chairperson of EC is to testify to the court on the truths behind the errors that the petitioner has outlined from her declaration in his petition, and also to account for how she conducted her constitutional duty as a returning officer for the presidential elections, particularly with the final collation of voting returns resulting in the Form 13 and the CI 127. This application to reopen his case for the sole purpose of issuing a subpoena to the chairperson of the first respondent to appear and testify as an adverse witness for the petitioner after all the parties had closed their cases was dismissed because the court in its ruling and the review clarified that the application was not supported by any law or settled practice. As a policy court and the court whose decision must be followed by all courts, we set out in our decision of 16th February 2021 the settled boundaries that every court must comply with if called upon to exercise their discretion and allow a party to reopen their case for the admission of new evidence. They are in two broad areas as follows. 1. Would the evidence, if it had been presented during the trial, have had any influence on the result? 2. Could the evidence have been obtained before or during the trial by the exercise of reasonable diligence? The review jurisdiction of the Supreme Court is properly invoked under Rule 54 of the Supreme Court Rules 1996 CI 16 and requires the satisfaction of two grounds. A. Exceptional circumstances which have resulted in miscarriage of justice. B. Discovery of new and important matter or evidence which after the exercise of due diligence was not within the applicant's knowledge or could not be produced by him at the time that the decision was given. Counsel for petitioner has asserted that it amounts to a fundamental error for this court to A. Fail to find that the first respondent depositions about being available for cross-examination should be conclusively presumed against her, such that she should be compelled to testify as a witness of the petitioner. He urges that this failure to properly construe Section 26 of NRCD 323 is a fundamental error of law. He also urges that this court's construction of adverse witness by relying on the definition contained in Black's Law Dictionary instead of Section 72 of Evidence Act constitutes another fundamental error. Third, he urges that by dismissing the petitioner's application to reopen his case for the sole purpose of calling the electoral commissioner as a witness of the petitioner, this court is shielding her and enabling her to evade cross-examination, contrary to a position she had deposed to earlier in the processes in this petition. It is the position of counsel for petitioner that the chairperson of first respondent is required to appear and testify to the truth of what happened in the election in dispute, to account to the people of Ghana for her stewardship as the returning officer of the presidential election, for which she had issued a first declaration and corrected that declaration with a press release the next day. She was also required to clarify matters arising during the cross-examination of the petitioner's witnesses. We disagree with counsel for the petitioner on all these grounds, urging alleged fundamental errors as constituting exceptional circumstances. This is the court of law and not a forum for suppositions. It must be stated that courts of law administer justice in accordance with law and settled practice, and no court can afford to lose sight of this. Further, this is the highest and the last court of the land, and our decisions on the questions of law have binding effect on all other courts. That before this court accedes to any application that is not covered by statute, the rules of court, or known general principles of law applicable in this jurisdiction, this court must ensure that it is not opening a Pandora box that can become a stepping stone for abuse of court processes at other levels of the judicial system. The interest of justice is not only the interest of one party in the dispute, but must necessarily be an outcome arrived at through the proper balance of what the law has prescribed as the duties of the court to all parties and the duties of the parties to each other. Thus, when the court has to exercise its discretion in an extraordinary situation, such as a party seeking to reopen his case after all parties have closed their cases, the court has to ensure that the discretion is consistent with statute, rules regulating procedure, principles of law, and settled practice of the courts. We have earlier in this ruling set out the guidelines that all courts must follow when determining applications for leave to reopen a party's case at any time after they had voluntarily closed their own case. Applicant has urged that this court failed to appreciate the import of Section 26 of the Evidence Act, NRCD 323. This submission is misconceived because we fully appreciated the submission of the petitioner's counsel, and found them wholly unsupported by any rule of law or rule of equity to which the conclusive presumptions is made subject. It is not the case, as urged by counsel for petitioner, that we allowed Order 38 Rule 3E5 of CI 47 as amended by CI 87 to take precedence over a substantive act of parliament. The Supreme Court reviewed the legal principles on the equitable doctrine of promissory estoppel that has been captured in Section 26 of the Evidence Act in the case of Clipper Leasing Corporation versus AG and Ghana Airways in liquidation, 2016, 100 GM, 1 Supreme Court. The holding of the court clarifies that for a statement to constitute conclusive presumption, it must be a statement of fact, and it must be clear, unequivocal, unambiguous, and unconditional. The promissor must have intended the promisee to act upon it, and the promisee must show that he acted on it and altered his position. Further, all the circumstances of the case will be taken into account in granting relief, and the usual maxims of equity will apply. From this premise, the first question to ask when the party alleges that a statement must be conclusively presumed against the maker of the statement is, was the promise clear, unequivocal, and unambiguous, and unconditional? Was the promise and the context of the promise such that the promissor intended the promisee to act upon it? Did the promisee show that he acted on it and altered his position? In the context of the case before us, we are satisfied that the positions in issue cannot satisfy the minimum threshold of being clear, unequivocal, unambiguous, and unconditional undertakings of the first respondent hearing to defend itself in this suit. At the time that the proceedings were made, the first respondent had already given notice in its answer that it considered the suit as disclosing no reasonable course of action and had gone on to file its submissions with respect to that position. All three parties had filed their submissions on this point. We found this to be the most determinative factor, that these depositions cannot be construed as clear and unambiguous undertakings that could give rise to a conclusive presumption that the first respondent will be defending itself in this suit. Again, the depositions were made by the chairperson of the first respondent as a representative of a party in this suit, and not in her personal capacity as a party in the suit. The decision whether or not to testify in the suit could only be that of the commission and not hers. The decision whether or not to personally testify on behalf of the first respondent commission is also not available to the chairperson because he is not a party to this suit. Further, cross-examination is only possible if there is examination in chief. Thus, if the first respondent, which is an organization, decided after the petitioner closed his case not to defend itself, the statements made as part of an affidavit in opposition indicating the options the petitioner could exercise if the interrogatories and other applications were disallowed cannot be said to have been unambiguous undertakings to submit either the commission through the chairperson or any other officer to cross-examination in a suit that had not offered testimony in chief. Counsel for applicant has also urged that this court failed to consider Section 72 of the Evidence Act, but rather relied on the definition in Black Law's Dictionary, and so the ruling and the review was per incuriam. We find no merit in this submission. Black's Law Dictionary is a respected and reputable source book for the bench and legal practitioners. Reference to law dictionaries is an accepted and respectable practice in common law jurisdictions, including Ghana. Furthermore, there is no inconsistency and contradiction between the definition in Black's Law Dictionary and Section 72 of the Evidence Act, as already determined by the Supreme Court. In Ray Okan disease, Dodu and another, there is Okan and others, 2003-2004, one Supreme Court of Ghana report, page 582. We are certified that it is the nature of testimony proffered by a witness that allows a court to categorize that witness as an adverse witness or hostile witness, and not the description of the witness as such. And so the submission that the witness was to testify as an adverse witness was no answer to the need to clarify the objective of seeking leave to reopen the case and call the chairperson or the first respondent as a witness of the petitioner. Section 72 of the Evidence Act provides 72(1). Subject to the discretion of the court, in a civil action, a party or a person whose relationship to a party makes his interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination at any time during the presentation of evidence by the party calling the witness. When such a witness is cross-examined by his own lawyer or by a party who is not adverse to the party with whom the witness is related, that examination is to be treated as if it was a re-examination. Clearly, the positive part of the provision in Section 72(1) is the fact that the person who calls such a witness has an interest that is adverse to that of the witness, and he is allowed to cross-examine the party he has called, and not that he merely described the witness as an adverse witness on the application to call the witness. In Ray Okan disease, Dodu and another versus Okan and others, Supra, the Supreme Court had the opportunity to review the distinction between an adverse witness and hostile witness. The court was clear that being an adverse or hostile does not arise from the description given by the party who called the witness, but the nature of testimony given by the witness. First, Dr. Sechu JNC had this to say in clarification on the general nature of witnesses and the specific nature of adverse and hostile witnesses at page 599. Quote, as a result of the testimony of the third plaintiff witness, namely that he did not see either the testator or the second plaintiff witness sign the will, counsel for the executors applied for permission to treat him as a hostile witness. Learned counsel for the defendants was right when he submitted that the witness should be rather treated as adverse witness and not as a hostile one. The reason is that any attesting witness will be a witness of the court and not that of the party calling him. End of quote. Professor Kluje JSC went on to state as follows from page 626 in his evaluation of when the witness is an adverse or hostile witness and the effect of the testimonies of the two types of witnesses. Quote, the trial judge, with the benefit of observing the witness, may choose to believe an adverse witness or part of his testimony. The fact that a witness called by a party gives an adverse or contradictory testimony does not lead to the irresistible conclusion that the adverse witness is an untruthful witness. The witness may be an adverse witness precisely because he insists on telling the truth rather than commit perjury in support of the fabricated story of the party who called him. Usually, it is difficult to determine whether the witness is merely adverse or hostile when there is no previous statement by him with which he could be confronted. In my view, a witness is a hostile witness if it can be shown that he knows the truth but deliberately persists in lying to the court. There may be different ways of arriving at that decision. End of quote. We did not see any fundamental error occasioned by this court's evaluation of whether the chairperson will be an adverse witness merely by her description as such by counsel for petitioner, even before she brings any testimony to the court. The issue that was determined by the ordinary bench is whether it is proper for the court to exercise judicial discretion and allow the petitioner to reopen his case for the sole purpose of calling the chairperson of the first respondent as his witness by the issue of a subpoena. Our determination was that it would not be a proper exercise of judicial discretion, and we do not see the miscarriage of justice that our decision occasioned, since petitioner continues to insist on not disclosing what new material the proposed witness is to testify on, and how that new evidence can change a judgment that is yet to be given. Counsel for petitioner also contends that the ruling was in breach of Articles 19, Clause 13, and 296, as it was unreasonable and irrational. Counsel for petitioner failed to draw the court's attention to any unfair exercise of judicial discretion exhibited by the Supreme Court against the petitioner, just because the court refused his application to reopen the case he had closed and to serve a subpoena on the EC to serve as an adverse witness. We would like to reiterate a time-honored principle of the adversarial system we operate, quoting the Supreme Court in Clipper leasing case again. Quote, the well-known policy of the law is that parties to a case in court are to know exactly what is that they are required to answer. And this is a requirement of fair hearing that the courts insist on. The requirement of fair hearing is a fundamental rule of natural justice. So a party cannot change its case on appeal when the opponent has no opportunity to adequately defend himself and lead the requisite evidence in his or her defense. The petitioner purported to present his full case in the witness statement submitted after the depositions in issue had been made. On the strength of those testimonies, including that of a third witness petitioner later called, respondents closed their respective cases. If the petitioner intended to rely on the depositions in issue, the law required him to state as part of the testimonies he would rely on the specific testimonies or documents he wanted the chairperson of the first respondent that petitioner has summoned before us to produce to aid the petitioner's case on the alleged strength of the depositions. As part of pre-trial processes, the parties and this court could have had the opportunity to tell me if truly the documents were not available in petitioner's custody, as happened in the application to produce originals of the polling station results, or the testimony sought was relevant to the settlement of the matters in controversy in this petition, as happened in the application to serve interrogatories. Statutes are construed and applied as a whole. No party or court may take part of a law and urge it to be applicable while ignoring the rest of the statute. Sections 10 to 14 of the Evidence Act lays down the burden of producing evidence and the burden of persuasion squarely on the party that alleges any position of fact or issue of law. Further, we stick to the time-honored principles that the Supreme Court has adopted in circumstances in which it reviews its decisions. Thus, in the case of Mechanical Lloyd Assembly Plant versus Nati, 1987-88 Uganda Law Report 598, page 603 to 604, and the DJS stated, quote, Let me say at once that for all I know, virtually every judgment on this earth arrived at as a result of evidence gathered from several sources can be criticized. A Privy Council judgment put in the hands of any lawyer, along with the evidence grounding it, can be criticized in the same way as a High Court judgment can be. A person who has lost a case will almost instinctively feel that the judgment must be wrong. And why not? If he had won, the decision would be right. So if he lost, how could the court be right? But the mere fact that a judgment can be criticized is no ground for asking that it should be reviewed. The review jurisdiction is a special jurisdiction to be exercised in exceptional circumstances. It is not an appellate jurisdiction. It is a kind of jurisdiction held in reserve to be prayed in aid in exceptional situations when a fundamental and basic error may have inadvertently been committed by the court, which error must have occasioned a gross miscarriage of justice. The review jurisdiction is not intended as a try-on by a party after losing an appeal, nor is it an automatic next step from appeal. Neither is it meant to be resorted to as an emotional reaction to an unfavorable judgment. Secondly, in Chapel Hill versus Attorney General and another 2010 Supreme Court of Ghana report, page 827 at 850, the Tiban JSC further set out the parameters for reviews as follows. Quote, I do not consider that this case deserves any lengthy treatment. I think that it represents a classic case of a losing party seeking to re-argue its appeal under the garb of a review application. It is important that this court should set its face against such endeavor in order to protect the integrity of the review process. This court has retreated several times without number that the review jurisdiction of this court is not an appellate jurisdiction, but a special one. Accordingly, an issue of law that has been canvassed before a bench of 5 and on which the court has made a determination cannot be revisited in a review application simply because the losing party does not agree with the determination. This, unfortunately, is the substance that the current application before this court is. End of quote. The application and the review was dismissed because it was not based on any known law or rules of practice. We dismiss the instant application as being wholly without merit.
As the court pleases. You are grateful to the court.
The panel will be reconstituted. All rise.
Well, the court has finally ruled on this review application to reopen Mr. John Mahama's case. You heard the delivering the ruling, the Chief Justice Kwesi Anini-Yeboah, that the application before them is not based on law or rules of court practice. It has been dismissed. Our lawyer, Bobby Banson, is with us. Good afternoon. Thank you so much for staying with us on this. Just help us to understand. This was a long decision. It's about 25 minutes of delivery. But essentially, what did you pick from what the Chief Justice said?
Well, the court has ruled dismissing the application for review, essentially on the basis that no error of law has been pointed out. I think the Supreme Court bench took their time to address each of the ground that was listed on the basis that they relied on the Black's Law Dictionary instead of the provisions of the rule, that they opted for subsidiary law being rules of court to override the provisions of a substantive law. And they have concluded by saying that they found no merit in the application, which not unsurprising, but they've really taken their time to give their reasoned opinion or decision on each and every ground of the application for review. I
found him reiterating most of the points that had been made in the earlier decisions. The whether or not they could compel the Electoral Commission chairperson to take the witness box. The reasoning they gave in that ruling appeared here. Again, we saw even in the review. So everything he said really is just something that he said before, this court has said.
Yes, you recall that when we had a discussion after the submissions had been made, I intimated that applications for review are not grounds to re-argue the motion that or the case that had earlier been dismissed, against which decision you are applying for the review. And ordinarily, the practitioners who appear before the Supreme Court will tell you that when you file an application for review and you appear before the Supreme Court and on the face of it, you've not demonstrated any error of law patent or apparent on the face of the record that has occasioned a miscarriage of justice, they'll not even waste their time. They'll just tell you that it has no basis and then they'll dismiss it, because if they want to go into the merits, then they will be tempted to go back to the substance of the case that they had earlier given a decision. Because of the nature of the application, the petition case in the Supreme Court, you realize that the Supreme Court, quite contrary to the normal practice that they do have, every single application, they give a reasoned judgment on it. And that will occasion going back to the merits of the case and re-emphasizing the fact they made, or they are very sure that they made no error of law when they stated that there was no legal basis for them to grant the early application by the petitioner to recall the EC chairperson to testify. So I believe that is why they went beyond just dismissing the application for review, but emphasizing the correctness of their earlier decision.
It's interesting, Mr. Bansing, that in all reviews, we've seen 3 reviews now from this petition. It sounds like the petitioner has not met the threshold to even get the Supreme Court to review the application, but they have, however, gone into it. Is it because it's an election petition?
Well, lawyers take instructions from clients. So if the client's instruction upon advice of the lawyers was that apply for a review, the lawyers have no option than to apply for a review. But we need not gloss over the fact that there have been some applications by the petitioner in this same case. The court has granted their application. So it's not as if for every decision or every application that the petitioner files before the Supreme Court, it is dismissed. I believe, like all lawyers know, the threshold for having a successful review is very high. More so at the Supreme Court, because then you'd have to demonstrate to them that there was an error of law. And this case being what it is, I believe the bench, with every decision that they would give, they'll make sure they have a solid legal basis, because it is not only about any private decision. It's about for lack of a better word, the power and authority of our country. And so they'll be very sure that they do not give any decision that is patently flawed, that has no legal basis, which would throw the justice delivery system into some kind of disrepute.
Well, let me just remind our viewers, if you're just tuning in, while the application for leave to reopen Mr. Mahama's case has just been dismissed by the 9-member panel. They've just taken a break. They will come back with the ordinary panel of 7 to continue with this case. So Mr. Bobby Benson is a lawyer. He's just been helping us understand what has played out in court a short while ago. Court says no fundamental errors committed, no miscarriage of justice, no new evidence disclosed, and what that evidence is expected to achieve. You can't review this issue any longer. This is the end of the road in terms of reopening of the case, correct? Yes,
this is the end of the road. Our constitution gives the Supreme Court as the final decision-making authority. There are a few instances where people have taken matters to the ECOWAS court and what have you, but I don't think that this is one that would go that far. So this is the end of it.
Okay. We know that, if I can say still to come, before this application though, the court had ordered the parties to file their written addresses. And I guess that a further direction in terms of where this case goes is what they would come back and help us understand. But from where you sit, I mean, there are no new, and I asked our court correspondent earlier, perhaps you're privy to something. Is there an application pending before the court on this petition?
No, I'm not aware of any other application beyond the stay of proceedings, which may be withdrawn because eventually this review decision has already been rendered. So it will render that application for stay moot. And so then the path will be clear for the court after all the past parties or their counsel have complied with their decision to file their written statements of case. Then they will give a date for the judgment on the matter.
Well, what do you make of the fact that the court has taken its time, I think in all 3 reviews now, to explain in detail their reasoning for dismissing, again, unanimously, an application that the petitioner has brought before them?
Like I said, it just goes to show how much the Supreme Court respect the petition before them, how they attach a lot of importance. And then they know that whatever decision they give will form the basis of a lot of things. You recall that the Chief Justice, Justice Kwesi Anini-Yeboah, said that they don't want to open the floodgates for abuse of the judicial process at the other lower levels of the court hierarchy. And it goes to demonstrate or to further how they want to take their time to make sure that every person who wants to read their judgments, their decisions dispassionately without bias would come to agree to the terms. You may not agree with the conclusion, but at least you give them the thumbs up for taking their time to analyze the position of every party. So it's not as if they discarded the applications or the reasoning by the petitioner's lawyers. They actually said, we hear you, we understand you, but we think that it is not in consonance with the known practice, procedure, and laws that bind the justice delivery system. So I believe that is why they've taken their time. Like I said, in most instances in the Supreme Court, if you file an application for review of their decision, the day you appear before them, they ask you, counsel, what is the exceptional circumstances? You are not able to demonstrate it in a matter of 5 or 10 minutes. That's it. They dismiss. They just write one-line ruling that the application is dismissed as being not meritorious, and that's it. But this time, you see that they really took their time, and as has happened in all applications before them, to explain the basis of the action and where the situation warrants, actually reiterate their earlier decision and the legal basis for it, so that you would not think that their reasoning is whimsical or without any legal basis. They've stated their authorities. The issue of the Black's Law Dictionary, for instance, for me was very clear that the fact that they didn't mention Section 72 doesn't mean that they've not considered the essence of it, because the definition in the Black's Law Dictionary is not different from the definition in Section 72. So they've not left the matter to chance for any person to wake up one day and say, okay, I have a case before the court, I'll choose to rely on the provisions in the Black's Law Dictionary even if the statutory provision is different, and want to quote this election petition as the authority. So the Supreme Court then would have to clarify any doubt in the minds of everybody that they chose the definition of an adverse or hostile witness in the Black's Law Dictionary. They prefer that one to the provision in the Evidence Act. So they have to take their time to explain their position and then draw the link between the two definitions. So I believe that is why they took their time, as they have done in all review applications, to explain their positions and re-emphasize the correctness of their earlier decision.
Well, this may be a tricky one, but if you're involved in the case and you've had so many unanimous rulings going against you, does it say anything or gives any indication what you should expect in the end?
Well, I would say no. You see, we have to be fair on this point. Judges rule on decisions based on what you present to them. It's as simple as that. So a judge may be right, a judge may be wrong, but whatever decision a judge arrives at is based on the facts and the evidence and the law that you present to the court. And so if throughout your case, you've presented facts and the evidence that on the application of the law will not warrant a decision in your favor, you do not blame the judges. And you would have to look back and say, okay, could I have done this well? And let me give you a perfect instance. I'm not without an attempt to prejudice the outcome of anything. But you see that the crux of the NDC case in this petition, the petitioner, is not the NDC, it's Mr. John Mahama in this matter, has been that this present or the applications from interrogatories to the application to reopen their case and then call Madam Jane Mensah has been based on the fact that they want to cross-examine her. And the purpose of cross-examination is twofold: to attack credibility of a witness and to solicit evidence in support of your case. Now, there's straight law authority that if by the time you close your case, you still require further evidence in support of your case, then it means that you have not discharged the burden of proof on you. So I understand where the lawyers for the petitioners are coming from, that they built their strategy in anticipation that the EC chairperson will testify. And then they would use the cross-examination to attack her credibility and then adduce further evidence in support of their case. So they may not, for instance, have adduced evidence of a pink sheet from even one polling station. I didn't see that attached to the petition, and I don't think there's been an amendment to the petition yet. And so the basis of their petition is that there was miscalculation, the figures were not right, and as Justice, I believe it was Justice Appa who asked them, where are your figures? They've not been able to document-wise provide them. And so I believe that they were hoping that when they get Madam Jane Mensah in the box, it will be an opportunity for them to attack her credibility. When I say her, not personally, but the credibility of the institution she's represented, and then try and adduce sufficient evidence to further their cause. But the procedure adopted in the opinion of the Supreme Court was wrong. And so as it stands now, the door is shut on them. They have no option than to rely on only the evidence that they have so far adduced. And if what they have said so far in all their applications, the positions they have made is anything to go by, then it seems to suggest to me that they think they may not have put their best foot forward yet. I want to see the next strategy or the next approach.
Okay.
That they may adopt.
Well, thanks a lot. We will come back to you after the court is clear in terms of how this case is going. If they give further directions, we'll come back to you. That's Mr. Bobby Banson right there. Kojang Singh is here with me. It's our election petition update in association with Petrosol, DBS Roofing, and Koa Mixture. Kojang Singh, the court has ruled again. It has dismissed this third review by the petitioner. They disagree that Mr. Mahama can reopen his case.
So all cases are closed. I mean, in the simplest term, that's where we are. Now it's time for what's written submissions.
Well, we're not sure what the court would say, except that before this application, that was the order that the court had given.
Yes.
A deadline for written addresses, and then the Chief Justice had said that he would give a date for judgments.
That's right. So in essence, there's no other business before the court apart from what they said that would happen next, which is the written addresses. There's no pending review.
We'll learn more when they return.
Oh, right.
Yes.
So they could still come in with some reviews.
Well, I don't know if a review, I don't know on what
some
matter.
Application or
but
submission or something.
This has been very complicated for you and I, so
It
we will
has.
still learn what they come to say next.
And yes, we continue to learn what is possible. Anyway, but cases are closed. That much we know, because each party closed their case and the Supreme Court has upheld the closure of each case. That much we know. So I'm thinking of a few things. First of all, the end is never the end. Even after the judgment is given, there could be a review of that judgment. That's the Supreme Court, right? So nothing ever really ends, even when you think it's ending. But how is the petitioner feeling right now? I'm wondering, you know. I'm wondering what's going through their heads. This is probably the 8th or 9th ruling of the court that has not gone in their favor. In fact, and these rulings have been unanimously not in their favor. So I'm wondering what they're thinking, like what's the way forward? We've gone through a process, we've presented our case, we've submitted all of our witnesses, we've made several applications along the way. All of them have been dismissed or denied unanimously, but somehow we must hope, or we have no choice but to hope that the final judgment will go in our favor. So I wonder how many options they are able to count on their hands right now of things they can do to influence the outcome at this point that their cases have been accepted as closed. Mr. Mahama, Mr. Chikata, they are going to have some interesting conversations, no doubt. But what it's going to result in between now and judgment, I really don't know.
Yeah, well, we all don't know. We'll learn the next directive that the court gives on this particular election petition. But one of the key things that the court also said is the fact that the lower courts learn from the Supreme Court. We'll take you back now.
My lords, we have before you two applications, one of which we've indicated we are withdrawing them. There's an application for stay of proceedings pending the review. The review has been disposed of, and we do not intend any further steps in relation to that application. We have an application for leave to file our closing address after the date that your lordships ordered, and in the affidavit in support, we've indicated also that we are withdrawing the motion for stay. Yes, my lord.
Lords, as regards the motion for stay, I have no objection to it being withdrawn.
Lords, the same.
By court, the motion for stay of proceedings is struck out as withdrawn.
Most grateful.
Yes.
My Lords, I move the motion for leave to file our address after the date ordered by the court. I move that applications in terms of the motion paper and the supporting affidavit. And my Lords, as we've indicated, the affidavit in support is sworn to by counsel in this particular case for obvious reasons that appear on the face of it.
My Lords, we are opposed to the application. We are opposed to the application, and we are opposing it by virtue of Rule 69C of CI 99, and also, my Lords, by reference to the case of Republic versus High Court, Tamale, ex parte Dapem, Zobuguna, Henry Kalim, civil motion number J5/6/2015, judgment of the Supreme Court dated 4th June 2015. Lords, in that case, it was held that the bare fact that an application for stay of proceedings has been filed does not operate as an automatic stay, so no party has the privilege to stay away from proceedings as the applicant did at the court below. Lords, if we look at the affidavit in support, the applicant or the petitioner is brazenly telling the court the reasons why he has refused to comply with the orders of the court. When established practice and the decision of this court is that the mere filing of a stay does not amount or give you the right to stay away from proceedings. Because this is the highest court of the land, and I think that obeisance to the rules and orders of the court are part of our practice. And insofar as the depositions clearly show that, yes, I chose not to comply with the orders for my own reasons, I pray that this application be refused. Your Ladyship, 69C of CI 16 as amended by CI 99. Yes. The 4B, Your Ladyship, with your kind permission, the court may dismiss the petition where the petitioner fails to file the processes regarding the petition within the specified time. Laws.
No, but we've heard the case to conclusion.
Pardon?
I said we've heard the case to finality. We are left with only closing addresses.
Yes, my Lord, it's part of the processes that we file.
My Lords, we are opposed to this application to the extent that the petitioner is not seeking the magnanimity of the court.
But what is he seeking?
He is asserting a right. My Lords, the petitioner, my Lords, if your Lords would refer to paragraphs 10, paragraphs 13, paragraphs 15, and paragraphs 14 of the petition. Lords, of the affidavit in support. Lords, the petitioner is seeking to tell the court what is convenient for it. So it says in paragraph 10, it would not be ideal for me to have to file a closing address without the testimony of the chairperson. In other words, the court has directed him on the 11th of February that we should all file closing addresses by the 17th. And he elects to tell the court that it will not be ideal for him to file, to comply with the court's order. On what basis can a party tell a court much more the highest court of the land?
It's coming from my friend on the other side. No, it's coming from
my lord.
That is the position in the affidavit you are referring to.
Yes. So, my lord, I'm saying that this deposition is a direct defiance of the court's order.
For leave to file,
but it's in the leave, in the application for leave, is an example of the defiance. That's what I'm saying. That it is one thing for them to come to this court contrite, and therefore the court should grant them leave. But they are trying to justify what they did, their defiance of the court's order. So, my lords, they may be advised to withdraw those paragraphs, offending paragraphs, and just plead to the court that they be granted leave. But this attempt to justify the unjustifiable.
So, preparing the decisions, you are setting, right?
Yes, because the application is based on the depositions. So they may choose to advise themselves and withdraw those depositions, of offending depositions. So that, because, my lords, if this court grants this application on this basis, it will set a precedent. It will undermine the court's well-established authority that a review application is not a stay of proceedings. Secondly, that a party who files an application for stay is not entitled to stay until the court grants it. Those are two very important, principles. And if the court grants this application based on these depositions, it will be undermining those principles. So our view is that it's all fair for the court to grant the applications, but it cannot be based on these depositions. No, it cannot be. And finally, my lords, they have arrogated to themselves the proposal of when they file. No, yes, I know that will be left to the court. But, my lord, will you hear me out? They have already had, since the 17th, since the 11th, now it's about how many days? 11 days. And they're asking for a further 72 hours. Meanwhile, we, under pressure, have met the court's order. So if they are seeking the court's leave, they should be filing this thing either by the end of the day or latest tomorrow, my lords, because they have indicated to your lordships that they already have a draft. Yes, but my lord, again, like their samples, they are saying this is a draft, so that it will give them the opportunity to go and produce something completely different from the draft.
Order in court, please. Order.
My lords, I will not dignify some of the comments on our conduct. My lord, there have been very serious comments made about our conduct, which I will not dignify with a response. I will not dignify them with a response, because saying that we filed something and then we'll go, I mean, these are serious allegations, but I do not wish to dignify them with a response. That's what I wish to say. I only wish to say respectfully that we have come to this court asking for leave. And in indicating that we are seeking leave, we have adverted in our affidavit to certain factual realities that we have had to deal with. Those factual realities include the fact that we have filed applications for review before this court. Those applications have been heard by this court and they have been dismissed. But we could not have contemplated that those applications would necessarily be dismissed, because we did not believe that there were predetermined outcomes for those applications. That was not the basis on which we proceeded. We did not believe that. And because we did not believe that, we took our time to deal with those review matters in the hope that after the review, we might have the chance to have a witness testify. The court has this morning decided, or this afternoon, the court has this afternoon
my
decided.
lords, with all due respect, my lords, he can respond on points of law at this stage. No, please, my lord, that is the process I mean.
Please, if the bench wants to say something, you defer to the bench, please.
Very well.
Mr. Contempt,
Very well.
before he could move the application formally, I had wanted to know whether any of you were opposing it. It is normally done in practice just to, as to manage time. So, well, I anticipated that, well, this is a colleague on the other side who has sworn to an affidavit explaining his inability to do that. He has annexed a proposed, normally we call it a proposed, not a draft, a proposed statement of case or whatever. So I thought that you were not going to oppose. That was why I cut him short and decided to ask whether you were opposing it or not. It is normally done.
Very well, my lord.
Yeah.
And my lords, in the affidavit in support, these clear circumstances in which we have found ourselves have been put before you. As a matter of fact, the paragraph 10 that counsel for the second respondent found so offensive. My lord, with respect, there is no offense to this court in the lawyer saying it would not be ideal for me to file a closing address without the testimony of the chairperson and then have to file a separate further component of should the review application be submitted. That is a very simple statement of the reality that we find ourselves in. So rather than get into all these things, we have given an indication to the court, and we say in paragraph 13, the deponent says in paragraph 13, I will crave the indulgence of the court to allow. We did not arrogate to ourselves a time frame. The position is very clear. I will crave the indulgence to allow, and this just gives an indication to the court of a time frame within which it will be feasible to file. How can anybody interpret paragraph 13 as imposing on the court or as not being, as not recognizing what the court's authority in this? The very heading of the application is motion for leave to file, and therefore we do not see any problem. But most fundamentally, we respectfully say, as in paragraph 15 of the affidavit, there will be no prejudice to the respondent by the grounds of this application, especially as they ultimately elected not to adduce evidence in support of their case. So, my lords, we have not had sight of whatever they filed anyway, because I believe the registrar may have been under some instruction, but the registrar did notify us when he was serving other processes that that particular process had been filed but not served. That was notified, and we have not sought to have that because we don't need it. Our legal arguments are not premised on what they have said. Our legal arguments are very clear. And your lordships may note that we call it a draft, my lords, for a very specific reason. Because it is not, as is clear on its face, it is not yet complete. It is very clear it is not complete. In fact, there are gaps in places where certain things are meant to be included. It's very clear. And so, my lords, we've indicated there's a draft, and we've indicated a potential time frame within which the lordships may be willing to grant us the indulgence of filing. And therefore, we respectfully seek the indulgence that we have asked for in our application to enable us to file our closing address. And my lords, may I finally say that when we stand here at the bar, we stand here as officers of the court. We stand here as officers of the court seeking to help the court advance the interests of justice. And in that regard, I believe that a closing address that presents to the court the case of the petitioner in its entirety is something that will be beneficial in the interest of justice.
Mr. Chikata, how do you reconcile this prayer that you are now making to the earlier statement which you made when you were on your feet, that you did not know that there were predetermined outcomes? I heard you clearly.
No, Mr. Chikata, we can play
Mr. Chikata, can you listen to me? When there is intervention from the bench, you have to listen. That is a practice we know from the bar. I heard you. I may not have heard clearly. But what I heard is what I'm asking. Now, how do you reconcile this with the earlier statement that you made, that you did not know that there were predetermined outcomes to the applications that you had filed? That was why you did not file your address.
Yes, my lords, what I
did you say that there were predetermined outcomes?
My lords, no, I did not say it in the terms that you have put it. What I said was that when we made our application for review, we expected that application to be successful. We did not know that there would be a certain outcome. And my lords, we can plead and but my lord,
you use the word predetermined.
Yes, my lords, I use the word in the context that
explain.
Yes, my lords, I use the word in the context of stating that what the outcome of that was not known in advance by us. So it was not, in our minds, it was not a predetermined outcome. That's the point I was making. For us, it was not a predetermined outcome. That is the fact. And that is what I said. That is what I said. And I believe your lordship has just indicated that that's how you understood what I said. And if your lordship understood it differently, that's certainly not my intent. I stated clearly that for us, it was not a predetermined outcome. And so we could not have, on that basis, prepared a closing address without reference to the potential of that witness being called. We could not have done that. That's a clear indication. And my lords, I mean,
by court. We are of the opinion that the petitioner should be granted leave to file his closing address on or before the close of Tuesday, the 23rd of February 2021, in the interest of justice. Yes. Yeah.
We're grateful.
Yeah. Yes. The petition is adjourned to the 4th of March 2021 for judgment.
My lords, I was actually going to make a preliminary before your adjournment. Is it possible that I may be heard on? Because my lords,
Yeah.
in terms of the filing of the addresses,
Yes.
I was going to respectfully draw your lordship's attention to the fact that there had been an earlier indication that
Yeah.
you would provide a time
Yes. For you.
oral highlights of my lords. May I respectfully finish? That time has passed. I'm aware of that. But my lords, in the light of the new orders, I was going to respectfully ask that after we have filed our written address, an opportunity may be available for your lordships to seek any. My lords, in the petition of 2013, there was an opportunity provided which enabled certain important legal issues that had been raised in the written addresses to be addressed by the bench and the council on both sides. And my lord, I believe that even if it's, you know, for a half hour, as the timekeeper has been rigorously insisting, that enables, you know.
Mr. Chikata, we have indicated that we are adjourning for judgment. Now, if we, upon reading your closing addresses, think we want some clarifications, we may come to you. But otherwise, we have adjourned for judgment.
Very well.
Order in court. Order, please. My lords, writ number J1/5/2021, Article 64 of the Constitution and Supreme Court Rules 1996 CI 16.
My lords, I take it that you are done with our matters. Very well. Very well.
As amended by
There is a contempt proceedings which the court
as amended by CI 74 and CI 99. Amended presidential election petition. Presidential election held on 7 December 2020. John Dramani Mahama versus Electoral Commission of Ghana. Nana Addo Dankwa Akufo-Addo. Dr. Dominic Akurutinge Ayeni, Contempt no. Lord, Contempt no present.
Oh, please, yes. Are you represented?
Yes, my lord.
Council, may you respectfully announce yourself?
Frank Beecham appears for the Contempt with Kukubram Labi and David Beecham.
Yes. Ms. Ayene, sorry, Honorable Dr. Ayene, please, you have been summoned here by this court to show cause why you should not be committed for contempt. Yes, because on the 16th of February 2021, you made certain statements which were very, very scandalous of the court.
Sorry.
Yes, we've exercised restraint in invoking our jurisdiction to always be committing people for contempt for obvious reasons. The other time, I think you were here when I drew the attention of Mr. Frank Davis. I think so also, yes, Lawyer Pong, then Marietta, the former learned Attorney General. I drew the attention and they stopped. But then, from nowhere, you also jump in onto the free end. You made certain scandalous statements which the bench thought that it was least expected of somebody who held a very high office as the leader of the bar when the Attorney General was not present. The Bar Association is just an association, but the Attorney General is the head of the bar. Yes, in every common law jurisdiction. So that is one of the enviable positions at the bar. Yes, I know the lead counsel was a president of the bar, but Attorney General, somebody who has acted as Attorney General, is the head of the bar, not the Bar Association president. And we want you to tell us whether you did say those words. Then we proceed from there.
My Lord Chief Justice, I did say those words. My attention was drawn to the fact that I might have crossed the line by Mr. Frank Davis, and Your Lordship, on the advice and consultation with my counsel, I have written to the court rendering an unqualified apology. I delivered that letter this morning to the Registrar of the Supreme Court to bring it to Your Lordship's attention.
So we have copies of the letter, and we've circulated it. Yes, we are comfortable with the apology, but we want to make certain consequential of this. Yes, Mr. Beecham. Yes, you can be heard.
Yes, my lord. With respect, our client has no excuse. Personally, as lead counsel for him, I was very disappointed at the article that I read last week and was deeply distressed when he called me last night. And I thought it was because I had made certain disparaging remarks expecting some action to stop this canker in the profession. It was to tell me that he had realized the error of his ways and pleaded for me to join him to render an unqualified apology to this court. He makes no excuses for that. He admits he is wrong and has been wrong. He deeply regrets the harm done to his profession, the disrespect shown to the court and to also to the country. I have his instructions to render his unqualified apology to every member of the Supreme Court and indeed the judiciary of Ghana and to the legal profession and people of Ghana that he's awfully sorry for what he's done. He is deeply remorseful and he deeply regrets what he's done. So, my Lord, our prayer is, yes, true justice has to be done, but we ask you to temper justice with mercy.
You are a former president of the Ghana Bar Association, is that right?
That is so, my lord.
I have been worried for some time now, listening to people granting interviews to the media, and not any ordinary people or lawyers, but people who have occupied very high position in this country. And we have to decide where we want to go as a country. In my view, the only reason why Article 88 of the Constitution, or the only ministerial position which is provided for in the Constitution, is that of the Attorney General, is that when you are appointed an Attorney General, you are appointed an Attorney General for the whole country. A party or a president may appoint you as Attorney General, but once appointed, you are the Attorney General for the whole country. And you are to ensure that every citizen of the country is given justice or has access to justice and fair trial. So when I hear former Attorney Generals and Deputy Attorney Generals mount or grant interview and make certain statements aligning in no uncertain term to one political party, it's something that worries me. And as a former president of the bar, I think you have to open a debate in that area about the proper role of attorney generals or former attorney generals, having regard particularly to Article 88 of the Constitution 1992.
My lord, with respect.
Two lawyers to support you. What we can do for your client is to let him go back and purge the contempt. Yes, he spoke to the whole world on television. Yes, he should tell the people that he's very, very sorry. What he did was wrong, and that is all. We are not going to find him, we are not going to give him a bond, but at least coming from somebody who has acted an attorney general, if we don't take any action, it is going to send dangerous signals elsewhere. That is all what we want to do for him. So if he does it today, the court will assemble on Thursday and just strike out this matter. That is all. We are not exacting any serious punitive would I say measures against him. All what we want to do is for your client who has confessed to whatever he did to he just go and apologize for the harm that he has caused to the profession and to the bench. This is our profession. Nobody can come from elsewhere to make it better. Yes, beyond the lawyers, nobody can come from elsewhere to make it better. Yes, we can make it. And it is a duty which has been imposed on us by our call. Yes, so please, let's all cooperate. At times you hear some comments by lawyers and you feel that they are killing the profession, because a time will come when nobody will come and sit here as a judge. Yes, we posted one judge to ECOWAS court as a high court judge. He's not the president. Whereas the other countries posted their Supreme Court judges there. A high court judge from Ghana was the president there. That's Justice Asante. We had a court of appeal judge here. He sought the leave of the Chief Justice to take outside an outside appointment. He's the Chief Justice there. And no matter what we do, please, the profession first. Yes, the profession first. And we should endear ourselves to the respect and whatever it will take to bring the profession to its past glory. So we thank you very much for not dragging this matter and coming with an unqualified apology. So that is what the bench has decided. We don't want anything from the former Attorney General, Deputy Attorney General, but all what we want is the retraction, yes, an apology, yes, through the same medium, and that will end the matter. If he does it, we'll come here on Thursday and have it struck out.
Yes. We are very grateful to you for this indulgence, and also taking the cue from the point made by my Lord Amugati, whose views I share personally, on a personal basis. And I did indicate to you why I stepped in, because I was even more worried when he called me. I thought someone had accrued that I had made disparaging remarks about his comments, but that's the point. But the right to be done, Lord. And we are profoundly grateful for your indulgence, and promise you that even before we came here, we had started the process of showing remorse and regret. Most grateful, my lords.
I will say something small, because Mr. Dr. Ine is a friend and a brother to me. I know he is a member of parliament and therefore a politician. But he should know how to talk when he is addressing the press as a lawyer, and then how to talk when he is addressing the press as a politician. There are two different things, because I know when politicians mount the witness box, they say anything, they can say anything at all. Then at the end of the day, when they are recorded, they come to deny. I've been a politician before. I know how it is. So you should know how to talk as a politician and then how to talk as a lawyer. They are different things altogether. It's like we've been insulted, judges are insulted by people who know nothing about the law, and sometimes who know nothing about the issue that is before the judge. And they talk and insult. If they are not lawyers, we don't care. Because if you don't want to be insulted, you cannot be a judge. But if you are a lawyer and who knows the law and who knows the procedure, and then you talk, in a manner, that does not speak well of you as a lawyer, it gives opportunity to non-lawyers to also talk or say worse things. So that's my advice to him as my brother. And a younger brother.
Yeah,
we are grateful.
You know what he has done? I remember when we went to the country. Ask him. I called him, and he was prepared to go to the news file to explain what obtains at the various faculties and why people should pick and choose and put their wards and children there to study law, not any faculty without lectures and whatever. And then, yes, the bench approached you, and you did it for us for free. Yeah, so these are some of the things that we can all, do to help the profession. It's nothing more. Yes.
So we are really grateful, and thanks for that.
And just one more thing from me. Mr. Dr. Yeni, as a former Attorney General, I have sat with you on the Judicial Council before. The two of us have judged to even appoint justices of the Supreme Court. The challenge, the difficulties, what we went through to appoint justices of the Supreme Court for this country. So after serving the Republic in that light, it's improper for you to go and make those statements to give the impression that the justices make decisions based on certain things. That's why some of us are disappointed at that statement. But having rendered this apology, we know, as my brother Justice Apau said, sometimes out of some kind of excitement or so, you are forced to make certain statements. As we've said here, we all make mistakes. We are human beings, and once in a while we cross the line, we make mistakes. So I'm happy that at least you've realized that what you said was overboard and you are prepared to retract it. But going forward, let's remember that we have one country and we all have a responsibility to keep this country together, no matter the circumstances and the situation we are confronted with. Thank you.
Lord, we are grateful for the admonition. I promise you, this will not occur. I'm grateful.
Yeah, by court.
Yes, my lords, with all due respect.
Yes.
My lords, before this matter commence, your lordship mentioned my name. My lord, with the greatest of respect, with all respect to this court, I just want it to be placed on record that I have not said anything to scandalize this court. I believe that...
I didn't say so. What I said was that when we started the proceedings, you were granting interviews, and we drew your attention to the new legal profession ethical rules. Yes, we drew your attention to it, and you were advised to stop, and you did.
My lord, your lordship, I no doubt disputes that.
Yeah.
But I think before the proceedings,
I never said you.
Something was said to that.
Oh.
Myself and.
Yeah. And
my lord, if that is the position of the bench, yeah. I'm exceedingly grateful. I don't want my name to be associated with scandalizing this court. As a former president of the Great Accra Bar, the longest serving president of the Great Accra Bar.
And the most populous bar.
Yes, and the most populous bar, arguably. Justice Amigache is not looking at me. I was the Mugabe of the bar, and I remain so.
Yeah.
I'm grateful.
Yeah.
I'm grateful.
I thought you were the Nkoswaini.
Yes, Prof, you can call me that. That was conferred on me by the Sanzeni Amesha as the Nkoswaini of the bar, so I still remain.
And we take this opportunity to also thank you for your end of year dinners for the bar. For the bar and the judges.
So far as that is concerned, Justice Apo can bear ample testimony.
So thank you.
With my eloquent service of blue label Scotch whiskey.
Thank you. Yeah, thank you. This is the order of the court. We accept the apology of learned counsel for the contempt law. We, however, order that the contempt law purges its contempt by retracting the scandalous statement on the very same medium before Thursday, the 25th of February 2021, when the court will reconvene. The contempt proceedings is thus adjourned to Thursday, the 25th February 2021 at 9:30 a.m. So, Mr. Bicham, so you will come here 9:30. If he renders the apology, you will come and completely vacate the order.
My Lord, just for some clarification.
Yes.
I don't believe we are expected to be here on Thursday. No, we just want to be, yes. Very well.
If you want to come and show solidarity, you are invited, you are at liberty to attend.
That's the end of the court processes today on the election petition. Well, before this contempt case was heard, the court had given direction. So we know that on the 4th of March, it will be Judgment Day. This case will come to a close. The court would give its final judgment on the 2020 election petition. We've got our lawyer, Bobby Bansing, joining us on Zoom. Well, towards the end of today's proceedings, Dr. Dominic Ayeni, a former Deputy Attorney General and Member of Parliament for Bolga East, was held for contempt. The contempt charges slapped against him for some comments that he made whilst he was addressing the media. Mr. Bobby Bansing, thank you so much for still sticking with us. So in the end, we know that the Chief Justice has said that they're comfortable with that unqualified apology that he's written to the bench, but they want him to apologize and retract the comments that he made, the contemptuous comments that he made. First of all, let me just pick your thoughts on what we've just seen and heard.
I would not want to say any more in respect of that, please. I become the target of another contempt application, but it just goes to show how the Supreme Court or the judges in general, and we as lawyers as well, must jealously guard this arm of government. I always say that I find it interesting that politicians, depending on which side of the coin they fall, tend to scandalize the court if a decision does not go into their favor. And judges are human beings. They listen to radio, they watch news. If you say things that are attacking not them as person in their individual capacity, I'm sure almost all of them would not mind if you say anything scandalous to their person. But if you scandalize the capacity in which they find themselves, then it goes beyond any of the judges sitting there. It goes to the very root of our existence, our constitutional rule as a country. And I was quite surprised, not in respect of Dr. Ayeni, but as soon as the list of the panel came out, some people belonging to one political party started saying, it will not be balanced. We know these people. Those kind of statements do not augur well for our justice delivery system. We accuse the executive arm of government as being partisan. We accuse the legislative arm of government as being overly partisan. And the only arm of government that we have that we cannot say it is partisan is the judiciary. And the moment we start, politicizing every decision of the judiciary, then there's nowhere for any citizen, ordinary citizen, to go. And I think that it's just for us to be very careful in some of our dealings when it comes to judicial decisions.
Well, I appreciate that, but for academic purposes, we're not saying that we can, for instance, take some of their decisions and look at maybe the ideologies or where they're coming from and arriving at certain conclusions. If you've studied their rulings for a period, you can come to certain conclusions. But of course, I don't want to take you into that argument. But let's talk about the fact that
I will not run away from it. The judges have never said that nobody should criticize a decision they make. They have never said that. They are human beings. Right from there. That is why we have the High Court. When the High Court makes a decision, the Court of Appeal has the jurisdiction to overturn it. It means that the High Court judge was wrong. When the Court of Appeal judges make a decision, the Supreme Court have the jurisdiction to overturn it. It means that the Court of Appeal was wrong. And even with the Supreme Court, when they make the decisions, they have a review jurisdiction to overturn their decision. And the Supreme Court have, even in subsequent cases, overturned decisions that they made in earlier cases. Supreme Courts, they say that their decisions are not binding. They may ordinarily treat it as binding, but they have the jurisdiction to depart from it. So they are not saying that don't criticize us when we are wrong. But the word is don't scandalize the court.
Sure.
Do not say anything that will bring the administration of justice into disrepute. And I think there's a thin line than saying that it's predetermined, as if that no reasoning will go into the process. I don't think that is something that it's hard for the judge to ask of citizens.
Okay, let me just get your final thoughts on the direction that the court has given. There was no date set for highlights of the addresses, even though the justices say that if in their own wisdom they determine that the council must do that, then they would let them know. But they've set a date for judgments. What does it mean? Break it down for us. Is this the end of the matter?
Well, the amendment to the rules regarding election petition stated that the decision must be delivered within 42 days from the day the petition is filed. And so I believe that the Supreme Court is being guided by that. It's completely not obligatory for them to give any lawyer or any counsel in the matter an opportunity to orally address them on any issues beyond what is stated in their statement of case or their written submissions. That's the word. So if the judges, in their own opinion, after perusing the written addresses, submissions that are filed, think that they need one or two clarifications on any point of law, they may issue hearing notices for the parties to appear, and then they will ask them to clarify that. But I think these matters are quite straightforward, and they will look at the evidence, they will look at the law, and then come up with a decision.
Mr. Bobby Banson, I am so grateful to you. You've been with us since morning, monitoring the process and helping us with some understanding. Very grateful that you could make time. Kojo Yankson is here. Kojo, we've got to wrap up. Gifty and Apia will come and continue with the polls and press addresses.
Yeah, I wonder the tone they will take now following the show of might by the Supreme Court. Yeah, there are many who will be speaking for the interested parties who are probably asking themselves right now, whom am I, whether or not they ought to come out as they usually do, because that was the platform on which Mr. Anyine is said to have committed this contempt. I wonder if it's going to shape or change the communication from the parties going forward.
Okay.
Mr. Anyine is certainly subdued today, isn't he?
Absolutely. Well, we have to take you back to the Supreme Court. One thing I've learned, though, the Chief Justice is certainly a big fan of Newsfile. He watches Newsfile.